Welcome everybody. Thank you so much for coming here today and giving your time. Today we are going to talk about my favorite topic, and it's SMEs. You might have thought SEPs, but I like talking about SEPs, but I love talking about SMEs. And even more importantly, sometimes here in Europe, we talk a lot about SMEs, but we don't always talk with SMEs. So we have people in the room who know what it's like to be in the trenches, to develop products, to work with customers, to try and create business plans and convince investors. And all this system of innovation depends on standards. Standards are incredibly important. And we want to make sure that the people who develop these technologies get fairly compensated. But the fairly is an important part of that. And so even though we've had FRAND be part of SEP licensing for a long time, the meaning of FRAND has diluted over time. And a lot of the SMEs that we've talked to have had to deal with very abusive behavior, have had a really hard time trying to license the patents that they need to implement these standards and get their products to market. So that's the conversation that we're having today. We're going to talk about the proposed SEP regulation, which cannot come soon enough for a lot of our member companies. They need the fairness, they need the transparency. And I'm very honored today that we have the rapporteur of the SEP regulation with us, MEP Marion Walsmann. She has been working very hard, and I think she will continue to work very hard to hear all the voices in this around the SEP regulation, to look at all the amendments, and to shepherd this regulation through the Parliament and the European institutions. So please. I'm very proud and happy to welcome the rapporteur of the SEP regulation, the Honourable Member of Parliament, Ms. Marion Walsmann.
Thank you for this warm welcome. It's a beautiful location. Good evening, dear ladies and gentlemen. I will speak in German and would like to give you just a moment to get your headphones in order to hear the translation. Meine sehr geehrten Damen und Herren, ich hoffe, es arbeitet, es funktioniert. Works? Just a moment. Ja, okay, it works. Ich möchte mich nochmal recht herzlich für die Einladung zu der heutigen Veranstaltung bedanken. Und vielen Dank auch, dass Sie durch die Übersetzung es ermöglichen, dass ich in meiner Muttersprache sprechen kann. Sehen Sie mir bitte zwei Tatsachen nach, die sonst nicht meine Art sind, aber es lässt sich nicht anders einrichten. Das erste ist, dass ich bis 17:30 Uhr im EU-Parlament noch die erste Schattenberichterstattersitzung zu SEPs hatte. Und deshalb nicht rechtzeitig oder nicht rechtzeitig genug da war, um vielleicht noch ein bisschen Vorgespräch auch zu führen. Und die zweite Tatsache ist, dass ich leider nach meinem kleinen Grußwort Sie schon wieder verlassen muss. Auch das ist schade, aber nicht zu ändern. Und deshalb sehen Sie mir das bitte nach. Ich entschuldige mich dafür und werde es irgendwann nachholen, länger dabei zu sein. Ja, Sie sind ja alle Experten, deshalb brauche ich in dieser Rede nicht mit einer Aufklärung zu beginnen, was genau standardessentielle Patente sind. Das wissen Sie genau. Dann lassen Sie mich mit einem Zitat anfangen, was irgendwo eine Überschrift für diese Zeit der Verhandlung sein könnte, in der wir uns befinden. Und das ist ein Zitat von Henry Ford. Es wird sehr oft zitiert, aber es beweist immer wieder Wahrheit. Zusammenkommen ist ein Beginn, zusammenbleiben ist ein Fortschritt, zusammenarbeiten ist ein Erfolg. Und warum zitiere ich Henry Ford? Ich zitiere ihn nicht, um den Vertretern der Automobilindustrie einen Gefallen zu tun, die auch heute hier anwesend sind, sondern weil dieses Zitat, glaube ich, ganz gut zu dem Abend, aber auch zu der Art und Weise der Diskussion dieses Berichtes passt. Und ein florierendes SEP-Umfeld ist von einer guten Zusammenarbeit geprägt und das sollte alle Interessenvertreter umfassen. Und wenn ich eine klitzekleine Kritik äußern dürfte, bitte gestatten Sie es mir. Es sollte nicht sein, dass die SEP-Inhaber in Straßburg eine Veranstaltung unter sich abhalten und die SEP-Anwender nun auch eine Veranstaltung unter sich organisieren. Ich glaube, wir müssen uns irgendwann der Mühe unterziehen, dass wir einfach zusammenkommen, denn wir brauchen eine Lösung. Und Zusammenarbeit erfordert, dass Sie in den Austausch miteinander treten und nicht losgelöst voneinander Ihre eigenen Positionen besprechen, denn das löst das Problem nicht. Und so kommen wir ja auch nicht richtig voran und genau das ist es doch, was wir alle wollen. Wir müssen Fortschritt erreichen in dieser Position. Wir müssen zu einer besseren Arbeit in diesem Feld kommen. Und ich bin der Überzeugung, dass SEP-Inhaber und SEP-Anwender einander brauchen. Die besten Erfindungen, meine Damen und Herren, die bringen überhaupt nichts, wenn es nicht jemanden gibt, der diese Erfindung nutzt. Und viele der heutigen Produkte, die auf Standards angewiesen sind, hätten ohne die von den SEP-Inhabern geschaffene Innovation nie entwickelt werden können. Auf der anderen Seite, was nützt mir ein Standard, wenn daraus keine Produkte erwachsen, wenn ich sie nicht umsetzen kann und wenn daraus nicht die Initialzündung für Weiterentwicklung kommen wird? Also es bedingt sich einander. Und deshalb würde ich mir wünschen, dass wir beide Lager dieses Konzept viel mehr beherzigen und gemeinsam nach Lösungen suchen, anstatt gegenseitig in einen Wettbewerb zu treten, der eigentlich ja keiner ist. Denn wir brauchen beide Seiten. Und meine Damen und Herren, ich habe ja schon einige Zeit im EU-Parlament und noch viel länger in der Politik hinter mir. Der eine oder andere, der in meine Biografie geguckt hat, weiß das. Aber so eine, ich möchte sagen, fast aggressive Form der Interessenvertretung mit der Verbreitung von vielen Fake News war mir bisher neu. Vielleicht hatte ich nur die smarten Berichte bisher. Es ist eine neue Qualität, aber lassen Sie mich sagen, ich habe meinen Teflonanzug an. Mich stört das alles überhaupt nicht. Ich bin eine ehemalige Beamtin, mich stört das gar nicht. Ja. Und ich lasse mich da auch nicht beeinträchtigen. Ich gehe da immer Klartext meinem Kompass nach. Das gefällt nicht immer jedem, aber ich kann Ihnen sagen, Objektivität und die Suche nach dem besten Weg, die ist bei mir, glaube ich, an der richtigen Stelle. Und wenn das der eine oder andere noch nicht erfahren hat, dann wird das jetzt erfahren. Also, und deshalb müssen wir gemeinsam auch für Aufklärung sorgen und dürfen dabei nicht aus den Augen verlieren, dass es um ein effizientes und ein gesundes SEP-Umfeld geht, dass wir die Eigentumsrechte stärken, aber auch die Innovation fördern müssen. Wir brauchen Innovation. Sie sind notwendiger denn je, um wettbewerbsfähig zu sein. Und wir müssen den Kritikern des Kommissionsvorschlages erklären, dass eine Regelung zu den SEPs einfach nur Licht in die komplette Dunkelheit der SEP-Verhandlungen bringen würde. Und diese Transparenz ist nötig. Das bestreitet im Übrigen auch niemand, dass ein mehr an Transparenz allen helfen würde. Dass Innovation verhindert werden würde oder gar das Recht auf Zugang zur Justiz behindert werden würde, ist genauso falsch wie die Behauptung, dass die Regelung gar nicht notwendig sei, weil ja so wundervoll alles funktionieren würde. Wenn das so wundervoll funktionieren würde, hätte die Kommission ein Arbeitsfeld weniger gehabt und hätte sich nicht so lange damit beschäftigen müssen. Also das ist, glaube ich, außerhalb dessen, was wir besprechen müssen, dass die Notwendigkeit besteht, oder? Genau. Und von der Einrichtung eines Registers über die Essentialitätsprüfung und das Verfahren zur Bestimmung einer Gesamtlizenzgebühr bis hin zum außergerichtlichen Streitbeilegungsmechanismus, alle diese neuen Instrumente, die haben ein Ziel: die Schaffung von Transparenz. Die bestehende eklatante Informationsasymmetrie zwischen den Verhandlungspartnern, sie muss ausgeglichen werden, meine Damen und Herren. Da führt jetzt mal kein Weg dran vorbei. Das ist eine schwierige Herausforderung, das weiß ich, aber wir müssen diese Leistung hinkriegen. Und wer besorgt ist, dass eine Erhöhung der Transparenz zu einem wirtschaftlichen Verlust führen würde, der sollte sich die Frage stellen, ob er wirklich seine SEPs unter FRAND-Bedingungen vergibt und er nicht den Markt verzerrt. Meine Damen und Herren, bei 84% der SEP-Anwender handelt es sich um kleine mittelständische Unternehmen. Vor allem diese benötigen die Klarheit, dass sie nicht über ein Team von Anwälten verfügen und die notwendigen Mittel haben, langjährige Gerichtsprozesse zu führen. Ich glaube, ich brauche das nicht auszuführen, was ich damit meine. Und das muss auch nicht sein. Den SEP-Anwendern ist es nicht oder nur mit einem erheblichen Aufwand möglich, sich einen Überblick darüber zu verschaffen, wie viele SEPs einen bestimmten Standard betreffen, wer die entsprechenden SEP-Inhaber sind und wie hoch die Kosten letztendlich sein werden, um einen Markteintritt unter Verwendung der entsprechenden Standards zu erhalten. Und darum geht es ja eigentlich. Was nützt uns alles, wenn wir nicht Produkte auf den Markt bringen? Und da müssen wir schneller werden, gerade in Europa. Also die Konkurrenz schlägt nicht, sage ich da nur. Und wir machen auf europäischer Ebene Vorgaben. Und wenn es dann dadurch geht, diese zu erfüllen, wird es den Unternehmen sehr schwer gemacht, beispielsweise smarte Messgeräte oder drahtlose Ladestationen, um nur 2 Beispiele zu nennen, auf den Markt zu bringen und sich dann auch noch auf dem Markt zu behaupten. Es ist ja nicht nur, dass wir den Markt mit unseren Produkten auch erfüllen müssen, sondern die Marktbehauptung, die Konkurrenz, die Wettbewerbsfähigkeit bildet ja eine Einheit. Und wenn dann noch durch Androhung einer Unterlassungsklage ein Produktionsstopp in Aussicht gestellt wird, dann bleibt nicht nur den kleinen, sondern auch den großen Unternehmen keine andere Wahl, als den Vertragsbedingungen oder beziehungsweise der Lizenzgebühr zuzustimmen, egal ob sie FRAND sind oder nicht. Und meine Damen und Herren, ein effizientes und faires SEP-Umfeld wird aber auch den SEP-Inhabern zugutekommen. Und davon bin ich fest überzeugt, denn sie werden genauso von der neuen Gesetzgebung profitieren. Manche muss man ein bisschen zum Glück zwingen. Und für mich steht zweifelsfrei fest, dass die SEP-Inhaber eine Vergütung für die Erfindung erhalten sollen. Sonst wird keine neue Erfindung entstehen und kein neuer Standard entstehen. Das ist auch klar. Und das stellt auch überhaupt niemand in Frage. Aber es muss eine Win-Win-Situation, eine faire Situation sein. Und ich hoffe auch, dass dieser Satz in dieser Veranstaltung nicht in Frage gestellt wird. Aber das weiß ich eigentlich von Ihnen, dass Sie da genauso denken. Und das ist mir wichtig und richtig, dass die SEP-Inhaber wirklich auch eine faire und angemessene Lizenzgebühr für ihre Erfindung erhalten, in die sie sowohl viel Zeit in die Erfindung als auch natürlich auch Geld investiert haben. Und für diejenigen, die unter fairen, angemessenen, diskriminierungsfreien Bedingungen lizenzieren, wird die neue Regelung auch Gutes bringen. Nur diejenigen, und es gibt ja immer schwarze Schafe, ja, die ihre Monopolstellung missbrauchen, würden durch die neuen Instrumente natürlich einen wichtigen Impuls bekommen, in die richtige Richtung sich zu entwickeln und Licht ins Dunkel zu bringen. Die SEP-Inhaber würden zunächst einmal von geringeren Kosten profitieren. Die Schlichtungsverfahren wären, ich schätze mal, im Durchschnitt etwas 8-mal billiger als ein Gerichtsverfahren. Sie haben da vielleicht konkrete Erfahrungen mitgemacht. Ich habe mich da belesen. Aber Gerichtsverfahren sind nicht nur angenehm, lassen Sie sich das sagen. Ich war früher mal Justizministerin. Ich habe immer darum gekämpft, dass man möglichst nicht in Gerichtsverfahren hineinschlittert, weil sie keinen Rechtsfrieden stiften, letztendlich in solchen Feldern, wo es um Verhandlungen geht. Die FRAND-Bestimmung als alternatives Streitbeilegungsverfahren kann die Beilegung von SEP-Streitigkeiten beschleunigen, da beide Parteien den Mechanismus ab dem ersten Tag ihrer Verhandlungen nutzen können. Normalerweise dauern Verhandlungen 2 bis 3 Jahre. Mit dieser zusätzlichen Orientierungshilfe, was eine FRAND-Gebühr ist, wird die Lizenzvergabe, hoffe ich, zunehmen. Durch das Register wird eine sichere Quelle der Information ermöglicht und die SEP-Anwender werden mit besseren Informationen einfach in die Verhandlungen gehen können. Aber auch die SEP-Inhaber ziehen aus dem Register Vorteile. Sie werden von einer größeren Bekanntheit ihrer SEPs profitieren, sodass sich Anwender nicht darauf berufen können, sie hätten nicht gewusst, an wen sie sich hätten wenden sollen oder bemängeln, das Patent sei nicht essentiell für den Standard. Also, es geht um die ausgewogene Situation, um faire Chancen. Und gestatten Sie mir mit einem kleinen Appell zu enden. Gehen Sie aufeinander zu. Kommen Sie zusammen, auch mit den SEP-Inhabern, bleiben Sie zusammen und arbeiten Sie zusammen. Denn nur so werden Sie alle von einem gesunden SEP-Umfeld profitieren, bei dem faire Lizenzverhandlungen geführt werden, die zu fairen Lizenzvereinbarungen führen und von denen beide Parteien letztendlich aber unsere gesamte Wirtschaft in Europa, und die hat es dringend nötig, profitiert. Ich wünsche Ihnen heute eine sehr interessante Veranstaltung. Ich werde mich erkundigen, wie Sie diskutiert haben, was Sie diskutiert haben. Bitte mich zu entschuldigen und nehmen Sie die Versicherung, dass ich um eine ausgewogene Verabschiedung arbeiten werde, die diese Win-Win-Situation zwischen beiden Seiten auch irgendwie zum Ziel führt. Herzlichen Dank für die Aufmerksamkeit.
Very much for those very insightful remarks. I think the quote that you used at the beginning, that we have to work together, is very important. I'm glad you quoted it in the original German. That's what we're going to do today. We're going to look at the different aspects of the regulation and see how it will impact the whole economy and the whole ecosystem. So thank you again once again.
Okay.
Ms. Walsmann. And now it's time for our panel discussion. We won't be needing the translation units anymore, so if you want to hand them back now or later, either one works well. And I will hand it over to Barbara, who will start our panel discussion and moderate.
Thank you so much, Mike. Welcome to the panel. We are here today with an excellent and diverse panel who will be discussing the SEPs debate from various different perspectives. And yes, we're very excited to hear everything you're here to contribute today. So to start off, I want to give all of you an opportunity to introduce yourselves. So please make some introductory remarks. And then also the first question is, why is the SEPs regulation important? So let's start here with Jonas.
Yeah. So hi everyone. Thank you very much for the invitation. I'm very happy to be here. I'm Jonas Heim from the Commission DG Grow, just recently joined the team. In fact, I'm a seconded national expert from Germany, the Ministry of Justice there. And now in the SEPs team, I'm very excited to be here. And I'm also happy that you arranged this meeting. I think the Commission presented a proposal that the Commission is convinced is the best and most balanced solution. But of course, now this is for the co-legislators to decide, and that's a process where it's very important to get as much feedback as we can from all stakeholders. And that's why these events are so important. So I like the phrasing of the question because it assumes that this is, in fact, an important regulation. And I think, in fact, that's one thing that, given the amount of advocacy we are seeing, and Ms. Walsmann hinted at that, most, if not all, stakeholders can agree on, in fact, that this is an important regulation in one way or another. So we have some consensual vision on this. And maybe a little background, just personally for me, 2012 was the first time I was confronted with SEPs and standard essential patent holder. In fact, I was studying in New York, and back then the Motorola versus Microsoft case was the talk of the town. You might remember it was about the Xbox 360. Today that would probably be in antiquariate, and it was decided before the ITC, International Trade Commission, and it displayed all the hallmarks of cases that we have today. So Optus, the Huawei case before the ECJ, the FRAND 1 and 2 cases in the German Supreme Court. We still have the same types of cases that we're discussing today under a different framework. And this different framework is different because the regulators did take steps. The FTC in the United States and the EU Commission here, they presented voluntary governance suggestions for SDOs primarily, and it was part and parcel of the FRAND setup that we have today. And I think this FRAND commitment and SDOs in connection with certain jurisprudence, specifically in the European Union of the ECJ and the national courts, has gone some way to alleviate holdout antitrust concerns. But it has also brought to the fore questions about the framework conditions of the negotiations on which these cases are based. Because no matter how you see this issue, in our view, there's just a simple fact that remains, and I think that almost everyone can agree on. Substantial information asymmetries persist between parties in FRAND negotiations today. And that's something that these court cases can simply not overcome. And they don't try to, at least not in the European Union. And we think that the urgency of this problem is growing. In fact, I mean, the data is well known to certainly all of you. I will repeat it nonetheless because I think it's staggering. We have an increase of 2 to 5G contributions from 2010 to 2021. This is in IP-lytics, you can look it up. From 396,000 to 1.25 million. We have, in the same time frame, 12,000 to today 72,000 patent families. We have an increase from 99 to 261 SEP holders. And I think this is also interesting as a data point, and you'll find it in our impact assessment. The share of Chinese companies in the SEPs increased from 15 to 30% over that period of time, while the European share, and I think this is important to emphasize, was reduced from 22 to 15%. And this fragmentation that we're talking about in the SEPs landscape is happening before a backdrop in which importance of connectivity is increasing enormously. So we have just recently, or I think yesterday, the OECD published a report which kind of puts together a lot of data points that are, I think, important or interesting to remember. For example, one, this is the United Nations Conference on Trade and Development, estimates that the IoT market will increase from 130 billion revenue in 2018 to 1.5 trillion in 2025. The EPO projects that 11% of all patenting activity worldwide in 2018 was regarding smart connected objects. And there's an increase since 2010 in patent filings for Industry 4.0 technologies by 4.2%, and that's 5 times greater than the growth of patenting in all other fields since 2010. So that just gives you an impression that the markets relevant to standardization and SEPs are growing, and they're growing fast. And as they are growing, the need to reimburse R&D costs is only outpaced by the public need to ensure that the statistics regarding SEPs are not inflated. And we think that actually this problem cuts both ways, right? For SEP holders, often they will not know who is implementing their SEPs. Ms. Walsmann raised this point. They face the risk of being held out. They might be forced to sue in different jurisdictions or be confronted with sham willingness to license. But more importantly, I think, they just don't know what SEP share they actually have in the total SEP stack. And this is an important problem to solve. And of course, you all know from the SEP implementer side, and particularly for SMEs, they have no way of knowing whether SEPs they're confronted with are in fact essential or valid. They have no way of knowing what actually a FRAND rate is. And if they are presented comparable licenses, well, then they don't know if they're the only ones or the most relevant ones to their case. So these are a number of issues that we see as central to the rationale of our proposal. And so to answer your question finally, why is this regulation important? Because we think it represents the next piece, maybe even the last piece, if everything goes well, of the puzzle of the SEP saga. It will provide much needed transparency, efficiency, and foreseeability to the SEP landscape. And our ambition is that it'll do so while ensuring that all end users have access to state-of-the-art products, and that it will boost attractiveness for the internal market for standard setting innovation, but also downstream innovation. So that's a tall order. We're aware of that, but we think that the situation that I tried to narrate demands a big proposal. So thank you.
Thank you.
We have our last panelist has arrived from London, Professor from the University of London. So sorry for the interruption.
So my name is Chris Thomas. I'm a competition lawyer from down the road. What I do and have done for many years is almost anything to do with technology and IP. A lot of that has become SEP negotiations and indeed litigation. So I am very, very familiar with the journey to Mannheim and to despair, and other places in Germany, the UK, trying my luck at DG Comp. So from that experience, what I would say, we're asked, why is this important? Well, the scenario we're dealing with is one of huge power discrepancy, which we can get onto in the details in a moment. But basically, we're in a situation where only the state can change this, either in the form of strong antitrust intervention or legislation. And where we are today is legislation. The other characterizing feature of this area is that Europe provides an enormous loophole enabling excessive prices to be charged, which is the court system in Germany that allows permanent injunctions to be granted without any real consideration of the validity of the patent, in a scenario when almost all patents are ultimately held invalid as granted. So we have the typical situation is injunctions being granted on fake patents. That's our normality. In the context of a system that has a very, very strong desire for automatic injunctions to be granted. So it's always been extremely difficult to win on an antitrust defense in Germany. And the Commission, through its cases, made some real progress there. I actually prefer the Commission's decisions to the Huawei ZTE judgment, but there we go. But even Huawei ZTE is kind of ineffective now when you get to Germany. So that's the way it's been interpreted. So there is a need for a degree of rebalancing. We'll get onto it in a moment, but I actually think this regulation is pretty modest in terms of rebalancing, but it is a step forward. So that's why for me it's important.
Thank you.
Shall I go next? Yeah, so thank you very much. Good evening. My name is Mark Graven. I represent the European Automobile Manufacturers Association, and as the name says it, our members are all the large manufacturers of cars, trucks, and buses in the European Union. Unlike many people on this panel, it seems I don't have such long experience with SEP licensing. I probably heard the term for the first time, I don't know, 4 or 5 years ago. Before that, we had always the pleasure of dealing with safety, emissions, even CO2 seemed like fun compared to SEP licensing at some point. But this is now very fast becoming very relevant for the automotive sector, of course, since we have connected and increasingly automated vehicles. This is where this comes in. If you ask us why this is important, then I would probably try to summarize that by saying that this is important to correct an existing market failure that the automotive industry has already experienced, and that if you haven't experienced it yet, you will probably experience soon. And that it's also important to promote European innovation. So just to elaborate a little bit on the first point, the German court system has been mentioned. This is one that has been used with some frequency against vehicle manufacturers. They've been at the receiving end of a good number of these injunctions, and that's why our members have ended up taking licenses from the SEP holders. Not because they thought they were being offered the terms that they should have been offered, the FRAND terms, but because the alternative to taking this license was no longer to sell vehicles in Europe, not a very attractive option, or to continue litigating endlessly. So that's our experience. And with the development of the Internet of Things, we believe that it will be your experience very soon. The importance of this proposal for innovation, I think, is also worth mentioning, because in this debate that is taking place, it is sometimes said also that the Commission's proposal would hinder innovation, is even a risk for innovation, is bad for innovation. And we think the opposite is true. The last time we checked the numbers, the automotive industry was the biggest investor in the EU in research and development, spending every year about 60 billion euro. A lot of it these days, of course, going into not only electrification, but also digitalization, connectivity, automation. And this is about 30% of the EU total, far ahead of pharmaceuticals or biotechnology or any other sector. And what we see is that the current practices whereby our suppliers are very often refused licenses. This has a negative effect on innovation, because if they don't get a license, they're reluctant to invest in new technology because they might be accused of infringing intellectual property rights. So they They don't make the product, they don't sell the product. And this is where then some non-European competitors come in, that companies that are already active in telecommunications, that have their own licenses, that become active also in automotive. I don't need to quote the names. And because they have licenses, they can make cross-license agreements with the SEP holders, and they do get a license, while European suppliers don't get a license. So these are the type of problems we see. That's what I think is important.
Good evening, everyone. My name is Tomas Navratil, and I serve as head of projects and digital strategist at Lucid Circus, and we are one of the members of the App Association. In that sense, we try to represent the industry side of things today, because many of our clients are startups and SMEs who often come only with business requirements or ideas, and we try to turn that into tangible products. Be it mobile applications, web applications, Internet of Things devices, middleware, that sort of thing. In that sense, we deal with SEPs in a more foreign or alien way at the moment. It's a concept that business people don't like to touch unless they have to. They have a very different perspective to my fellow panelists, probably because it's not something you want to dedicate your budget early on, unless you have to. You go through the necessary research for IP to ensure you can build the product and push it to market. However, it's not an area which is very transparent. It's quite opaque, and it's very difficult to navigate through it if you don't have legal or academic background. Of course, many companies who have investments through venture capitalists might have access to these sort of resources. However, it's not always the case. There are very often scenarios where product ideas might get either backburned or rejected completely due to some of the complexities that are involved in SEP licensing. In that sense, the regulation as it stands at the moment should provide or should level the playing field for SMEs who might not have the necessary resources to be in a strong negotiation power with large companies and enterprises who are some of the major SEP holders. In that sense, from an industry perspective, it will finally bring transparency and predictability as well, where it would be easier to put numbers in a business plan related to IP. At the moment, a lot of the predictions were based on opinions and random predictions that were not really based on reality because of NDAs in place, and unfortunately the limitation of getting the right information about the SEPs you might need for the product. So every step of the way, from trying to understand what SEPs you actually need for your product, trying to understand who's the owner of these SEPs, and trying to understand if the proposal you are given is fair, is very difficult at the moment for SMEs. It's not a word that is very, day-to-day for them. It's something they need to abide to. However, they don't like to do it. And I feel that this proposal, also thanks to the guidance and support that the European Commission and European Parliament tries to create through it, for example, through the Competence Center and other information sources, should act as a natural bridge between the legislation and the industry. Thank you.
Thank you. My name is Enrico Bonadio. I come just from London just a few minutes ago. I teach IP law, do research in the field of IP law in London, and I've been interested in SEP issues for a number of years now. So my aim has been to try to find a balance between the protection of patents and protection of consumers and competitors. So I think this proposed regulation, as many of you have already said, of course, increases transparency, effectiveness, predictability, blah, 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 blah. But I want to just focus on a specific criticism that this proposal has, attracted. For example, just a few weeks ago, the EPO president, Antonio Campinos, expressed some criticism, saying also that such proposal may not be proportional and therefore constitutes a violation of a fundamental right to property, right? You know, the Charter of Fundamental Rights, Article 17, paragraph 2 protects IP as fundamental rights, including patents. Then we have the European Convention on Human Rights, Protocol 1, Article 1 protects property, which includes intellectual property. So some criticisms, criticisms have been highlighted. But does this really, that is the regulation, proposed regulation, violates such fundamental right to property? Well, I think, in my opinion, it doesn't, because there can be interferences with the right to property, right? In the past, we have plenty of cases where IP rights have been balanced with other overriding public interests. It's not the first time. I mean, look at tobacco packaging. I mean, we have cases where tobacco companies have to accept the fact that the ability to use the brands of the package must be curtailed. So that IP rights are absolute rights is not true. We need to accept that. And I'm not talking as an IP minimalist. I love IP. I like IP. I think patents should be protected and the investments should be rewarded, right? But it doesn't seem to me that this proposal constitutes a threat to such fundamental right to property. I'm explaining why. I mean, even in the Huawei case of 8 years ago, July 2015, the Court of Justice balanced two fundamental rights: patents and interest of competitors and final consumers. I mean, limiting the exclusive rights of SEP holders has been possible in that decision. No? There has been a procedure to be followed, blah, blah, blah. So I think this proposal goes in those footsteps, right? It continues. It's an unfinished business, basically, right? In my opinion, it doesn't come from the moon, right? Also, if we look at another fundamental right which has been highlighted as potentially violated, Article 47 of the Charter, on right to access to courts, right? It's a more procedural right. Well, again, this is not an absolute right as long as restrictions do not impair the right's essence and are proportional. My opinion, they are proportionate. I also look at international treaties such as TRIPS. I mean, it's the architecture, right, of IP at global level, TRIPS agreement. And if we look at Article 7 of the TRIPS agreement, it seems very clear. IP protection enforcement should lead to a balance between the rights of IP owners and the users of technology. It's very clear. And we are talking about the most important IP treaty in the world, right? So I think, and then maybe later we go on more specific provision, I think that this proposal goes into the right direction and does not excessively jeopardize. Of course, we need a limitation. Everybody knows that. But the limitations for the greater good, right? And I think this goes in the footstep of the rulings of the Court of Justice, not only in Huawei, but also in other non-IP related cases. IP rights are not absolute, and they are also contingent. Just to pick up on the comments made for contingent means that patents may be invalidated, like trademarks may be invalidated. So there is also a difference between a tangible property and intangible property. And intangible assets are not forever. They are not set in stone, right? And I'm not talking from, as I said, an IP minimalist position. I recognize the importance of IP. Right? So maybe later we can go more in detail with specific provisions, specific principles of that. But this is my general comment to start with.
Thank you. Moving on to the second question. Why is it important to clarify the methods of FRAND rates and their determination? And how does this relate to the current state of licensing practices?
I was going to have a go at starting that one. And I will take us So you ask a competition lawyer, you're going to get a competition lawyer's response. Think back to where this starts. What is going on in standard setting? What you have is a collection of licensors who would normally have to go out and persuade companies that their intellectual property that their technology is useful and valuable, that their IP is valid. What they actually do in a iterative, very lengthy process, and I say it's a multi-iteration game. I look back and the LTE releases, so the thing that's licensed as one thing, LTE, the releases themselves went over a period of more than 13 years. Even before we get to the earlier development work that led to the first release. So what we've got is a constant game in which SEP owners keep coming back into the same room and agreeing which of them will get their technology into the standard, and thus, if it is cellular, Wi-Fi, or most video codecs, for example, is absolutely unavoidable for the licensees. So it's a bunch of people sitting around in a room many, many times over periods of years, deciding who gets their technology in, who will have a monopoly to license their now wonderfully valuable IP. And this is why patent owners put such huge efforts into getting their technologies into the standard. It creates a scenario in which, out of this group coordination, we create huge power. And the power is simply to charge whatever you like. So in literal terms, the power that is created, and I talk in terms of power because that's what I do. As an antitrust lawyer, you work with power. And they have the power to charge what they like. Years ago, when GSM was coming into fruition, the European Commission saw the dangers of this and it forced on Etsy, then a relatively modest thing, this notion that SEP owners should commit to fair, reasonable, and non-discriminatory terms. So now what we've got, and the hope there, is simply that because there's a contractual promise to carry out some works, that this will make abusive licensing less frequent. It's no more than that. It's a hope, and it only is going to have any effect whatsoever depending on the extent to which people can actually make use of those contractual rights, which is where we get to it. So what does a licensing negotiation look like? It looks like, so first of all, the normal way you do it is you end up looking for what so-called comparable licenses as a reference point. Where the SEP owner will say, oh, well, everyone else is willing to pay this, so you should pay it too. How does that work in practice? Well, what an SEP owner will do is they go to a number of very small companies and say, this is going to cost you X dollars a unit. But honestly, bearing in mind your turnover, that's not so huge compared to the devastating cost of litigating against me. So you're going to sign up. So they sign up a number of people with low turnover, but high per unit rates. And then they start going for the bigger boys and say, oh, look, comparable licenses. It's really, really valuable. So that's how comparable licenses work. Then we get top down. So top down is, I say that all the patents in a particular standard must be worth X, and the X might be X% of your end product. And I say that I own 20% of the patents. And guess what? I got some economists to back me up. Now, the other guy who's also trying to get a license off you, he too says he's got 20%, and he says that I've got 5%, but that's wrong. So everyone has very, very different estimates depending on what they're asking for. So then you think, oh, let's go and have a look at the Etsy database, which is, of course, completely useless for this purpose, serves no benefit whatsoever. There is, only, say, the US patents are declared, or people have put in general declarations. There are consultancies in India who make an absolute fortune for searching that and trying to calculate the actual patents in the database. It's incredibly expensive, and it's all proprietary. So it's done for one licensing negotiation or one litigation, and then it's put in the bin, and then they earn exactly the same money by doing the same thing again, and no one else knows because no one's ever going to see it. So the information is kept completely obscure, which enables the patent owner to say, indeed, by the way, I think it's 5% of your product and I own 20% of it. So you've got to give me 1% of your sales. You actually have no idea how many patents I have or what value I've given. So now there is another concept which is sort of bottom up, which is really trying to work out the actual contribution of the technologies. So do they make the product better, faster, quicker, more reliable? It turns out that that's hopelessly impractical. No one ever does it. Because when I turn up and say, I've got a portfolio of 500 or 1,000 patents, good luck to you trying to hire experts to try to work out the actual value of my supposed technologies. So that never happens. The end result is the SEP owner just sets out the case. They say, this is what you owe me because other people are mug enough to have paid it. And you will then say, oh, please, can I have a look at your comparable licenses? No, of course not. Please, can I look at your list of what patents you think are actually essential, as opposed to the ones you declared 15 years ago? Oh, no, I'm not going to give you that. You get a complete denial of information. The patent owner will simply sit back and rely happily in the knowledge that when it gets to a fight in court, they're going to take you out in Germany. You won't be able to sell a single product in Germany because they'll get an injunction against you. And that's the way negotiations happen. And when you hear people say that we have a perfectly functioning market because people make agreements, that is because people realize quite quickly that they are hopelessly outgunned and they have to surrender. That's how we make deals in this industry. So what does the regulation do for that? It puts in provision for an expert opinion on a total aggregate royalty. I think that could be helpful. I think it would be very difficult because, total aggregate royalty for what? For end products, for components, for which products, for which components? It is hard. Who are the experts? Are they going to be knowledgeable enough? Are they going to be impartial? Those kind of things are very important, but at least it's a step forward. What I do think is, forgive me, appalling, is the notion that we're going to legitimize SEP owners, the competitors, to get together and agree what they would like as the total aggregate royalty. I mean, bearing in mind that the total aggregate royalty is a key price component in these negotiations, and these guys are competitors. This is exactly the scenario of all the benchmark cartels, LIBOR, TIBOR, all those other financial derivatives where the commission has been fining people hundreds of millions, billions of euros for doing exactly this, that they're now going to promote in this regulation. Just seems very strange to me that we're going to encourage these people to get together and work out how much money they would like. Last point, and I realize this is going to come up later, but FRAND determination before patent litigation. at last, this is a great idea. It's this kind of pre-litigation protocol is very good. I have some suspicions and cautions. It's weird that it is only going to apply to standards adopted after the regulation comes into force. Why? What's that got to do with it? These are licensing disputes that will happen after the regulation comes into force. It's litigation that happens after the regulation comes into force. All the disputes, are about old standards anyway. So it seems calculated to make this ineffective. As I said, LTE is 13 years. 5G they started issuing releases, 2016 or something, and it's still going on. So when we license for 5G, I take it then that all of those disputes are not going to be protected by the regulation because of this choice. Why? I have no idea. I literally cannot think of a reason why you would exclude today's disputes from the regulation. However, the basic idea of getting people to do FRAND determination first is a good one and a solid one. My only problem is last word, but it's non-binding. So when we have our 9 months FRAND determination, the conciliator is going to say, okay, I think the right price is X. And then the SEP holder will go into the court in Germany, get his infringement, get his injunction. And will the court pay any attention to this finding at all? No. So you've given us 9 months stay of execution. Great. It needs to have some teeth on it for it to be effective. But the core idea of making people work out, having a third-party FRAND determination before you go to injunctions is a really good one, which of course was the Commission's Motorola and Samsung decisions, which I like, and which in a way I see them coming back in this. So thank you.
Thank you. Would anyone else in the panel like to address the questions?
Yeah, maybe very briefly. I don't know if Mr. Thomas has represented one or more of our members in these cases, but it almost sounds like it. But if not, it was probably
not that have gone to litigation.
Not to litigation. Good, but what I've just heard is things that I've heard also from our members many times. So I don't need to repeat that, certainly not. But when it comes to the FRAND issue, I would just like to go back to the basics. The FRAND commitment that SEP holders make, I think, is absolutely fundamental. And because standard essential patents are not model patents. They put these companies in such a strong, dominant position where you have no alternative but to use the technology that they patented and that is part of the standard, and that's why special rules apply. I think that's sometimes forgotten, but shouldn't be. And then if implementers, potential implementers find themselves in the situation that was just described before German court, for example, we also think this mechanism that the Commission is proposing here is good because it puts some kind of pause on this issue, and it brings it a little bit back to the sphere of negotiations or alternative dispute settlement. We think it's absolutely essential that this mechanism remains mandatory before anybody can enforce patents or go to court. And equally, we didn't understand why this would only apply to future patents. I mean, we see all the issues that are there, that will be there for a long time, with 5G, for example. And if none of that is covered, it seems a relatively little use, at least for a good period of time. Certainly, it would be better if it were binding. On the other hand, perhaps I'm naive, but one could perhaps also hope that if this mechanism were to introduce as a mandatory step for enforcement, that might have an impact in changing the general behavior of companies. Also, the knowledge that this mechanism exists might result in companies behaving differently. If this mechanism is beginning to be used, and these opinions are beginning to be rendered, one would also hope, or could hope, that over time that courts take these into account and don't completely ignore them. At least that's what I would hope. Last point, perhaps on this point, we would also think that it's not a good idea to let parallel proceedings outside Europe interfere with this process. There's a provision also in the draft regulation that says that if there is a parallel proceeding taking place outside Europe, then the FRAND determination process in Europe would need to be stopped. We don't think that's a good idea unless the party that initiated it agrees. But otherwise, it would be too easy to start proceedings outside Europe to, in a way, torpedo what's happening here.
Great. Thank you.
I can just very quick. No, the reason why it's good to have these conciliators, right? Proposing FRAND, or trying to get the parties agreeing on a figure. I mean, I think part of the answer is also in the regulation, Article 27, which says that, these conciliators, also evaluators, shall ensure confidentiality. They shall adhere to and respect a code of conduct, right? Respect any act of the union relevant for the conduct of their task, and they will be carrying out their tasks with the highest degree of professional integrity, right? These are all important characteristics. Of course, it will take probably little time to get started, but I think this is good. I mean, it may and it will create a controlled environment where these tasks can be conducted with calm and without the threat of an injunction based on the standard implementer, of course. And let me just expand on a criticism which is another criticism about that. No, they said, some have said, no, but these guys from the UIPO, they are trademark guys, they don't know anything about patents. Well, I mean, I think it's a weak objection, right? Because they can recruit some patent or some experts in the field. I think it is quite easy to do. The UIPO has funds, lots of funding, was very successful, right? As an institution. So I think this is a very weak objection.
Great, thank you. So moving on to question 3. Dennis, do you want to make a?
No, I don't want to get in the way of your time schedule. All right, well, because there were a couple of points at the commission. I don't want to answer all of them, but I think some of them, maybe I should. So first, you were frustrated about, or maybe I should start by the fact that I used to work as a corporate lawyer. So I am now in government. What I like about government is that we have to find balanced solutions. We have to make trade-offs. And you can see from this panel that this is the complex task that this regulation tries to address. And so with respect to the scope, that's exactly what we did. We made a trade-off. And it's not entirely true that we're only including existing new standards. And by the way, new standards means the publication of a standard. So 6G, for example, at least we were to conclude this regulation in time would fall under this regulation. but also existing standards can be included based on a delegated act that the Commission would have to publish, and that it would need to consult all stakeholders for. And that is simply the case because in case of regulation, if you are trying to regulate past cases where stakeholders, actors have already based their decisions on, where they have created property values, you are under a higher justificatory bar to regulate. And that's what we're doing with this Article 66, paragraph 4. And this is why we regulated the scope as we did it. With respect to the fact that FRAND determination is non-binding, I think that's a competence issue. If we were to include a binding conciliation process prior to court proceedings, then we would regulate into national procedural law. And the European Union simply does not have that competency per se. And so that's another one of these trade-offs that we make. But I do think, and I think that's the point that you made, that FRAND determination has the chance to set precedents. So I think, because this was the original question, why is it important to clarify the methods of determining FRAND terms? Well, we're not determining which FRAND method or which method we have to use to determine FRAND. Why? Because we think that it will be a question of practice. So the reports that this FRAND process will produce will include publicly the information on the methodology that the conciliator used to reach a royalty rate. And this is an iterative process. Let's say 10, 15 years down the line, there will be hundreds of these reports, and we will have a clear understanding of what best works, whether it's the comparative approach, whether it's the top-down or bottom-up approach. This is not the Commission's role to decide this, and it's something that will be found in an iterative process. So I guess those are points that I would range out. You said aggregate royalty is a difficult process. We agree, but that's not a reason why we shouldn't set up a framework that makes it possible. Yeah, that's my point.
Thank you so much, Jonas, for tying up the discussion. And indeed, I think this really well highlights that from some participants, some stakeholders, there's a call for even more beyond regulation. So thank you for explaining why it is as it is. But it's really great to hear about the point of views also beyond what might be needed and wanted. Moving on to question 3. Why is it important to increase transparency in SEP licensing? And how does the current regulatory proposal achieve this? I'll refer to Thomas first.
Thank you. Overall, as it has been mentioned in the previous question, if you are an innovator, if you are a company owner, and you have a really cool idea, at the moment, your start for even searching the information might be quite challenging. It's not an easy research that you can do on your own. So you might have increased costs very, very early on during your product discovery and your product development, which could be challenging if you are an SME and you have a financial runway for, let's say, in IT, very typically 3 months, 6 months, 12 months. You have developers on the payroll, and you need to look at the IP aspect. Well, you say, well, okay, where do we start? Is there a database? Can we easily search it? You realize there's not, because Mr. Thompson Bell explained, why there are many reasons why you cannot easily go and search SEPs that you need and pick the ones you need and purchase them. So you enter this process of negotiation, but again, you cannot do it on your own. As a business owner. So when we link that to transparency, if there was an open database with precedences that you could search, methodologies that you could search for determine the rates and how the average rate that would be published whereabouts were created, then it would help you massively in terms of understanding the budget implications very early on of your product. So you can build it into the financial plan, you can build it into the business plan. or you can assess if the given technologies are actually needed for your product, or you might choose a different strategy. That's unfortunately not possible today, because often you get a letter, with an offer, and you have no idea if that offer is good or bad. So you just have to take it, or you're risking basically injunction, which could put your company out of business because you just don't have the runway to be at court for several months. It's as simple as that. The small and medium companies just don't have the bandwidth to accommodate injunctions, especially if it happens in multiple markets and they try to be global, unfortunately. In that sense, access to guidance, support, and information and tangible data on rates would be a massive help in this scenario.
Thank you. Anyone else from the panel have a question?
I just want to add a data which is important, which justifies the introduction of these transparency provisions in the regulation. Several studies on important technology demonstrate that when strictly assessed, only between 10 and 50% of the per patent are really essential. This study was cited by the European Commission communication of November 2017, and it's self-telling, it's self-explanatory. And this calls for action, right? And I think that the commissions have made some efforts to improve a weakness in the system. It's there, the data are there. They cannot be really disputed. That's just this.
Yeah, just because this is a really central part of this proposal, transparency, I'd like to say some things, and it ties into another point. And I remember I had another point I wanted to raise, so I have all the stuff I want to say. Right. So I think it's become clear that in our view, transparency simply levels the playing field here. That's basically the underlying rationale. And what we want to do is we want to construct the type of framework conditions that the jurisprudence, the ECJ, basically, and we are, of course, sailing in the wake of this jurisprudence, necessitates. And I want to connect to the point that you raised earlier that, well, then we'll have a FRAND determination and then the German courts won't care. If I were the lawyer litigating this case, I would point to the ECJ's specific wording in its decision in which it says that it is possible, in the case that the parties don't reach a FRAND commitment, that they include a third-party conciliator to determine that FRAND rate. And that is specifically in the wording of the ECJ, and that would be something that I would point to when I have a FRAND determination report that I want to point to in my litigation case. So I think it ties into existing jurisprudence. I think it will be effective before courts, not just in Germany, in other courts as well. And I think that's just an important way that we can level the playing field in these negotiation settings. And I just wanted to maybe just tie into something that you said earlier with respect to parallel proceedings. I think that's Article 47 or 48 or something. Just so that everyone knows, in the FRAND determination process, the question is, what do you do if one of the participants in this FRAND determination process files a lawsuit in a different jurisdiction, right? It could kind of override this FRAND determination process, because once there's litigation somewhere else, you could just basically focus on that. So the regulation tries to deal with this question: what happens if one of the parties to the FRAND determination process files a lawsuit somewhere else? It's a so-called parallel proceeding. And in paragraph 2 of that article, it says that the conciliator shall terminate this proceeding, the FRAND proceeding, at the request of any of the other parties. So any of the other parties of the FRAND determination, because they can be more, right? So it is in fact not the case that this proceeding, the FRAND determination, will be terminated in the case of a parallel proceeding. It will only be terminated if any of the participating parties in the FRAND determination requests so. So I just wanted to clarify that point so that you guys don't go home thinking that basically we can just override the FRAND determination process by filing a lawsuit in a different jurisdiction. That's something that the Commission took due note of, right? So, yeah.
I love the optimism. I don't mean it completely cynically, because I genuinely do think that, I recognize that we move in steps.
Yeah.
And to have mandatory pre-litigation conciliation process with FRAND determination is a big and significant step.
Yeah.
And however much you are the target of things being thrown at you because you're the designated target. Genuinely, it would be a huge improvement if that took place. I wanted to, if we're on transparency, I wanted to add one more thing, which is a plea to anyone with power who might be listening. One of the tricks of licensors is through the confidentiality provisions in negotiations to make sure that their claim charts claiming their patent as essential to a standard, or the evidence that is put forward by the implementer negotiating with them about how that patent does not read on the standard, or that the patent is invalid, to make sure that that is all suppressed when the negotiations are concluded with a license. And because that is treated as confidential information, it seems to me truly bizarre that patents that are declared, that are offered as standard essential patents, where basically, we, the public, should be the beneficiaries of this. It just seems completely bizarre that the materials relating directly to whether or not those patents are in fact essential can be kept secret. And it is. That is, all this stuff is secret. So the last 20 years worth of negotiations, all the evidence about whether these patents are not essential is all secret and not available to anyone. Wouldn't it be just a tiny, nice little provision somewhere in this regulation that says you can't keep secret information about the essentiality of a declared essential patent? Just a thought.
Thank you. Thank you so much, guys. Moving on to question 4. What are some other practices that the SEP regulation addresses, and why are these important? So we've heard mention from the panel already about refusal to license, overboard licensing, injunctive reliefs, and the issue with essentiality checks. And I also want to ask the question of what are your opinions on the regulation introducing non-binding expert adjudication for SEP licensing disputes through the EU IPO?
Perhaps I can start with this one. I will not try to address all the points, but perhaps focus on 2, starting with the refusal to license, which is something that I mentioned earlier as something that vehicle manufacturers, or actually suppliers, are confronted with. So we're familiar with this issue. When I first came into this discussion about SEP licensing, I must say I couldn't really understand that companies could make this commitment, and then later refuse to license some companies willing to take a license because they thought, well, they were not in the right place in the supply chain, or more likely that they could make more money by licensing to someone else, and then still claim that they offer a license on FRAND terms. Until today, I have difficulty understanding that. The Commission didn't include such an obligation of licensing to all willing licensees in the proposal. Perhaps there was another trade-off. I don't know, but that's an issue, I think, still, that if it's not addressed today, that someday probably needs addressing. I mean, I mentioned the negative impact we see it having in innovation in our sector. The other thing that happens, of course, is that the vehicle manufacturers then end up paying higher royalties. Also, probably then rewarding the SEP holders for something that they should be rewarded for, which is the innovative effort made by other companies, other suppliers, on top of the in this case wireless communications technology. You need that technology for data transmission to and from the vehicle. That's why you need to pay the royalties, because they make that possible. It's very important. But then everything else that comes on top, navigation systems, safety systems, more and more automated driving in the future, all that is developed by other companies. And it seems that because the SEP holder is negotiating with the vehicle manufacturer, they can somehow be rewarded also a part of that, because it's very important for you when you sell all these additional features. But that's nothing they invented. So I think that's the first issue. The other one, again, not directly addressed in the Commission's proposal, there are some amendments in the European Parliament referring to it, that is patent pools and perhaps also licensing negotiation groups. We also think that if not in this regulation, then in another EU regulation, some more attention needs to be paid to patent pools and how they operate. We find them also not very transparent. We see that often a portfolio of licenses is offered, and it is difficult or impossible for licensees to have bilateral negotiations with the members of this patent pool. There appears to be also bundling of standard essential patents with non-essential patents. So we see a number of practices that we believe need addressing. That's for the patent pools. When it comes to the licensing negotiation groups, that is perhaps a less developed activity, and that's because there is more uncertainty about the legal nature or the compatibility with competition law of them. We think they are a natural complement to patent pools. We think it's only fair that both sides should be able to cooperate in these negotiations on the right terms, of course. We think that also licensing negotiation groups would reduce transaction costs, because it would make it easier for the SEP holders to reach the very many implementers in the Internet of Things, or even if they want to enforce their rights. And of course, for the implementers, we have the big benefit of reducing the existing asymmetry in information that exists between them and the SEP holders. So these are the two interesting items, I think, that are not so much addressed in the regulation, but should also be looked at soon.
There we go. If I may to add a few points from the SMEs perspective, what we commonly see is the SEP holders trying to delay the negotiations as much as they can in order to conduct their own market research on the matter. So let's say you enter an NDA, a mutual NDA, and you share information how you are planning to use the SEP. And often in that phase, you're held up, basically. So one very common tactic that many of our clients deal with is not having the licenses available in a timely manner, mainly due to the SEP holders likely conducting their own research, trying to understand how this changes, the market balance for them. If it does at all, it might not. And secondly, if they realize that the company could be a threat, it's very, very easy for them to either try to get an injunction or say, it will come to litigation. So you have two options. You can drop the product, or you can pay this fee, which could be devastating for you, or you might risk it. So from a business owner perspective, at the moment, based on the current regulation, it's a very high risk situation that the proposal luckily addresses. The second thing is the overbroad licensing, which is very, very common. If it was for the SMEs, they would like to have a pick and choose, the standards that they actually need, rather than multiple or bundles or pools that they need to deal with. They'd like to talk to one person if they could on the given SEP, rather than multiple, and understand the stakeholder situation. But often, if you need a specific SEP and the SEP holder understands that thing is essential for your product, and they understand that you cannot really progress to market without that SEP, they would very likely, and it happened in the past in many scenarios, they would bundle other stuff to it just for sake of it and for earning more money, as simple as that. And unfortunately, as an SME, there's literally nothing you can do, especially in situations where the product in question is already in development, not just a research phase, because you try to get to market in a timely manner, you try to beat some competitors. So your options in that scenario are unfortunately quite limited.
Thank you. So regarding the non-binding expert adjudication, Enrico, would you mind commenting on this topic of why it's important that this is addressed by the regulation?
I already said something before on my answer before. I think it's good to create this environment where these issues can be discussed with the conciliator, right? Even if it's not binding, the environment which is created with professionals, we have to conduct their activities with the highest standard of professionality. All these may create an environment which helps, which facilitates reaching an agreement. So even if it's not binding, it's a welcome scenario, might be, right? Which may help, especially in a highly litigious environment. These kind of settings usually help finding a solution.
Is there still time, or?
So we are running short on time here, so I think we're reaching the conclusion of the panel. But before we end, I would like to ask one last question. So very short, very brief. I would like to have everyone answer, what is your message to SMEs who are currently struggling with SEP licensing issues?
Well, I'm as you say, an optimist. So I live in a world in which this regulation is adopted. And if this regulation is adopted, then I'd say reach out to the Competence Center, because it offers training and support to SMEs in precisely these kinds of situations. That'd be my answer, short.
So I would go, 1, don't sign NDAs that prevent you from proactively complaining to competition authorities, which is the typical NDA that is signed, because it will say the commercial exchanges are confidential information, and you may not disclose confidential information to anyone absent legal compulsion. And you can't get legal compulsion because you can't approach the competition authority in the first place to disclose it. So actually, in a world in which the DMA explicitly prohibits actions to stop people talking to competition authorities, it is simply bizarre that this is the normal routine way in which SEP holders act to isolate themselves from European competition law. So that's 1, don't sign those NDAs, force them to either explain why they want to stop you talking to the European Commission, or come up with something more reasonable. Don't be misled by the assertions that SEP owners make about what others are paying, because they are simply declaring their list prices. They're not declaring the real ones that are actually agreed in the bulk deals. And lastly, press the SEP owner for information in writing. Don't rely on your meetings with them, because what they say orally will disappear from the record, and no one will ever admit that it happened. But other than that, it's genuinely very hard today, and logically it should be, because the power differential is so great. It's very, very hard to do anything about that. I do think as I said earlier, recognizing all the whinging that I've been doing, nonetheless, this is the first time that anyone has tried systematically to make a difference. So also look forward to the regulation would be what I would say. But let's just hope it comes out a little bit better than it currently is.
Well, I would say until the happy moment arrives where you can actually go to the competence center, I'd say two things to the SMEs. One is just we feel your pain. We know what it is. That doesn't help you very much, but you have our sympathy. And secondly, make yourselves heard. Make yourselves heard by as many policymakers as you can. We sometimes hear from those policymakers that this looks like a big fight between two elephants, the auto manufacturers and the telecoms. And they say we need more voices out there. So make yourselves heard.
And if I may add, I mean, the regulation, it is written recital 12 that in order to raise awareness and facilitate SEP licensing for SMEs, the competent center, the UIPO, should provide free of charge assistance to SMEs. So they should get advantage of this tool and to get in contact, to start a conversation with the center, the competent center, also in a language which is not English, because the regulation provides for automatic translation. So SMEs from non-English speaking countries can still use the system. Hopefully they won't use ChatGPT to translate them. But of course the UIPO, the competent center will find solutions to translate. So take advantage of those, free of charge assistance tools.
Just building up on that, staying informed is essential. Be more proactive. Often SMEs feel that they are not heard, and EU regulation is just something that is a burden. It doesn't have to be that way, but that's just in Czech Republic, for example, that's the current perception. However, if they are more connected through, for example, the competence center and other mechanisms and framework to European Union and regulation more closely, they can influence, as we are doing here today, hopefully, we can influence the outcomes that could help them to be more innovative in a more equal environment, hopefully.
Thank you very much. So thank you for all the excellent contributions. And as we're running short on time, we're not going to have time for questions.
But we can continue the conversation. We're going to have some refreshments. We're going to have some snacks. There's been a lot of very interesting talking from this panel. One of the things that I loved the most was that we had both the perspective from the trenches, but then also people looking at the big picture and looking at systemic solutions. And so I think this is, it's like, help us, Obi-Wan Kenobi, you're our only hope. This SEP regulation cannot come soon enough for innovators in Europe. And let's have the conversation, let's continue, and I hope we have a lot of continued questions and answers and questions and conversations.